August 10th, 2019. A Saturday morning in New York City. The Metropolitan Correctional Center, a federal detention facility tucked into the concrete canyons of Lower Manhattan, has a reputation. It has housed terrorists, cartel kingpins, war criminals, men who the United States government considered so dangerous, so valuable to ongoing prosecutions, so irreplaceable to pursuit of justice, that they could not be allowed to roam free under any circumstances. On this particular Saturday morning, in a cell on the 9 South Unit, one of the most consequential federal prisoners in American history was found unresponsive. His name was Jeffrey Edward Epstein, and within hours of that discovery, something happened that almost never happens in the modern media age. A moment of genuine, collective, bipartisan shock that cut across every political divide in America. Democrats and Republicans, liberals and conservatives, the left-wing Twitter sphere, and the right-wing talk radio world. Everybody looked at the same set of facts and arrived at the same stunned, disbelieving place. This doesn't add up. The man who allegedly possessed information capable of destroying the reputations of careers and possibly the freedom of some of the most powerful people on earth, presidents, princes, prime ministers, billionaires, celebrities, was dead. Not dead after a trial. Not dead after testimony. Not dead after he'd had a chance to sit across from prosecutors and tell them everything he knew. Dead before any of that could happen. And the circumstances surrounding that death were so riddled with failures, so packed with statistical impossibilities, so strange in their specific details, that even people who had spent their entire careers dismissing conspiracy theories found themselves unable to look away. Here's what the official record tells us about the night Jeffrey Epstein died. He was placed on suicide watch after a previous incident in late July, just weeks before his death. Then, and this is not disputed, he was taken off suicide watch. His cellmate was transferred out and never replaced, leaving him alone in his cell. The 2 guards assigned to check on him every 30 minutes fell asleep, both of them, at the same time, and then, according to the official log, failed to check on him for approximately 3 hours. The cameras outside his cell malfunctioned. The footage was, according to the Bureau of Prisons, unusable. Every single safeguard, every single protocol, every single redundancy designed to prevent exactly this outcome failed simultaneously. Now here's the thing. I'm not standing here telling you that Jeffrey Epstein was definitely murdered. I am not going to do that because I am not going to present speculation as fact. What I am going to do is give you something more disturbing than a theory. I'm going to give you the documented reality of what we know, what has been released, what has been testified under oath, and what has been quietly buried in court documents most people will never read. Because here's the truth that the headline cycle never gave you enough time to absorb. Even setting aside the question of how Jeffrey Epstein died, the story of what he did, who helped him do it, who protected him while he was doing it, who made deals to keep him from facing real consequences, and who has walked away from this entire catastrophe without facing a single consequence. That story is darker than the death. The death gets the memes. The death gets the t-shirts. But the files, the actual files, those tell a story that should have ended careers, that should have produced criminal referrals, that should have shaken every institution that touch this case to its foundation. And in most cases, it didn't. This is that story. All of it. To understand what Jeffrey Epstein became, you have to understand where he started, because the distance between those 2 points is one of the most remarkable and revealing trajectories in modern American history. Jeffrey Epstein was born on January 20th, 1953, in Coney Island, Brooklyn. His father worked for the New York City Parks Department. His mother was a homemaker. They were working-class people. Modest circumstances. Nothing exotic. Nothing dark. Nothing that would suggest the arc that was coming. But even as a young man, people who knew Epstein described the same quality again and again. An intelligence that wasn't just sharp. It was predatory. He didn't just understand problems. He understood people. He understood what they wanted, what they feared, what they were insecure about, and, most importantly, what they could be convinced to trade in exchange for the feeling that a man like Jeffrey Epstein found them impressive. He was admitted to Cooper Union in New York. He dropped out. He was admitted to the Courant Institute of Mathematical Sciences at New York University. He dropped out again. 2 of the finest mathematics programs in the country, and he couldn't finish either one. But here is where the story gets interesting. Here is where you see the first clear evidence of a skill that would define his entire adult life. The ability to make people believe in him so completely that normal rules cease to apply. Without a college degree, without a teaching certificate, without any formal credential whatsoever, Jeffrey Epstein talked his way into a teaching position at the Dalton School. If you don't know Dalton, understand this. It is one of the most exclusive, most expensive, most socially elite private preparatory academies in all of Manhattan. The children of senators, of CEOs, of old money dynasties and new money tech fortunes walk its hallways. Getting a teaching position at Dalton, legitimately, on the strength of your credentials, is difficult for people who have spent years earning the right qualifications. Epstein did it with charm, with mathematical ability, and with an almost supernatural confidence that seemed to preclude the possibility of being questioned. And at Dalton, he found his first real door into the world he had decided he was going to inhabit. One of his students was the son of Alan Greenberg, known as Ace Greenberg, the chairman and CEO of Bear Stearns, one of the most powerful investment banks on Wall Street. Epstein tutored the boy. He impressed the father. And Alan Greenberg, in a decision that still raises eyebrows among financial historians, offered Jeffrey Epstein, a college dropout with no finance background and no verified experience, a job at Bear Stearns. Epstein took it, and he was extraordinary at it. Not because he was a financial genius in the traditional sense, but because he understood something about wealthy people that most financial advisors miss. Wealthy people don't just want returns on their money. They want to feel like they are in an exclusive club. They want to feel like they know something other people don't know. They want to feel like the man managing their money is connected to something larger than the market, something that can't be quantified in a prospectus. Epstein gave them that feeling. By 1980, he was a limited partner at Bear Stearns. Then, in 1981, he left. The circumstances of his departure have been the subject of significant journalistic investigation, and the full picture has never been made entirely clear. What is documented is that questions had arisen about his conduct, and that his exit was not on the most celebratory of terms. But rather than that ending his ascent, It simply redirected it. By the mid-1980s, he had established J. Epstein and Company, a private financial management firm that, according to Epstein himself in various interviews over the years, exclusively served clients worth more than $1 billion. The firm had no public-facing offices in the traditional sense. It didn't advertise. It didn't recruit. It existed in a legal and commercial space that was almost impossible to scrutinize from the outside, and that was almost certainly not an accident. Journalists who tried to identify his client list came up essentially empty. Investigators who later tried to follow the money found a structure of offshore accounts, shell corporations, and layered financial vehicles that had clearly been designed by someone who understood, at a granular level, how to make money invisible. And then there was Leslie Wexner. Wexner, the founder of L Brands, the retail conglomerate behind Victoria's Secret, Bath & Body Works, and Lane Bryant, was one of the wealthiest retail entrepreneurs in American history. He was also, by multiple accounts, a man of genuine intelligence and caution, not the kind of person who made financial decisions carelessly. And yet, beginning in the late 1980s, Wexner granted Jeffrey Epstein something that has almost no parallel in the documented history of financial management: an unlimited, all-encompassing power of attorney, not over one account, not over one property, over essentially everything. Wexner gave Epstein the ability to make financial decisions, real estate transactions, staffing decisions, and legal decisions on his behalf, without Wexner's case-by-case approval. The New York Times, the Miami Herald, and multiple investigators would later note that this arrangement was so extraordinary, so far beyond the normal boundaries of any financial relationship, that it demanded an explanation that none of the parties involved were ever willing to fully provide. What we do know is that through this relationship, Epstein acquired assets that would define his public image for the rest of his life, including the 9-story townhouse on East 71st Street in Manhattan, which was originally purchased by Wexner and transferred to Epstein under circumstances that were the subject of significant legal scrutiny. But beyond the money, beyond the properties, beyond the private jets, what the Wexner relationship gave Epstein was something far more valuable. It gave him the most powerful possible introduction to the world of the ultra-wealthy. It gave him a front-row seat in a social universe where the normal rules of verification and accountability simply didn't apply to anyone with enough money and enough social proof. And Jeffrey Epstein, the college dropout from Coney Island, was about to use that seat to build something that the world had never quite seen before. By the early 1990s, Jeffrey Epstein had assembled what can only be described as a physical infrastructure for power. Every property was a venue. Every venue had a specific function. Every function was designed, with remarkable precision, to place Epstein at the center of a world in which the most influential people on the planet came to him, not the other way around. The Manhattan townhouse on East 71st Street was the crown jewel when investigators entered it in 2019. They described a property that seemed almost impossible in the context of a single private home in a city as densely packed as New York. 9 stories, over 21,000 square feet. At the time of its transfer from Wexner to Epstein, it was considered the largest private residence in New York City. But the size was not what left investigators shaken. It was what was inside. Photographs entered into court proceedings, Photographs that have since been described in detail by reporters who reviewed them showed a property that seemed designed to disorient, unusual art, custom installations, massage rooms, a room that contained a vast collection of photographs, many of which, sources told journalists, appear to include images of young women and girls, and cameras installed throughout the property in ways that, according to investigators and witnesses, did not appear to be standard security equipment. They appeared to be for recording. Recording what? Recording whom? For what purpose? Those questions hang over everything that comes after, and they are questions that the full official record has never completely answered. In Palm Beach, Florida, Epstein maintained a 14,000-square-foot estate that would become the epicenter of the criminal investigation that first brought him to legal accountability in 2005. It was there, on El Brillo Way, that the pattern of abuse that prosecutors would eventually document was most concentrated. A world of hired recruiters, organized transportation, regular schedules, and a rotating cast of young women and girls who were brought to that house under various pretexts and subjected to abuse that multiple victims described in extraordinarily consistent, extraordinarily specific detail. Zorro Ranch in Stanley, New Mexico was different in character but similar in function. 8,000 acres of remote desert, a private airstrip, a main house of extraordinary size, complete isolation. Guests who arrived there were, by definition, guests who had accepted Epstein's invitation to enter a space that he completely controlled, where there were no witnesses beyond those he chose to have present, where the nearest town was miles away, and where the rhythms of daily life were entirely determined by him. And then there was a plane. The Boeing 727, tail number N908J, later re-registered as N120J, was not merely a convenience. It was a mechanism. Private aviation is, in many ways, the ultimate expression of the kind of power Epstein had built, because it removes the one element of commercial travel that even the very wealthy cannot entirely escape: documentation. When you fly commercially, there are records, there are passenger manifests, there are security checks, there are witnesses in the form of gate agents, flight attendants, and fellow passengers. On a private plane, especially one that filed flight plans under corporate registrations rather than individual names, the paper trail could be managed, the guest list could be controlled, and the destinations, including private islands in the Caribbean with no customs infrastructure, could be reached without the kinds of checkpoints that might generate inconvenient records. The flight logs from Epstein's planes would eventually become among the most scrutinized documents in the entire case. They would surface in civil litigation, be referenced in congressional hearings, and be partially released through court proceedings. And the names on those logs, which we will discuss in detail, would represent a who's who of late 20th and early 21st century global power. But of all the properties, of all the venues, of all the infrastructure Epstein assembled, it is Little St. James Island that has lodged itself most permanently in the public consciousness. Purchased in 1998 for approximately $7.95 million, Little St. James is a 72-acre island in the United States Virgin Islands. Over the subsequent decade, Epstein developed it into a compound of almost theatrical grandeur. There was a main house, guest houses, a private dock, a helipad, a library, staff quarters, underground tunnels, the purpose of which was the subject of extensive testimony and speculation. A blue and white striped structure that multiple witnesses describe in their accounts of time spent on island. He later purchased the adjacent island, Great St. James, for approximately $18 million, expanding his private domain to nearly 200 acres. The people of the U.S. Virgin Islands had a name for Little St. James long before American prosecutors took any serious interest in what happened there. They called it Pedophile Island. That was not a name that emerged in the aftermath of Epstein's 2019 arrest. That was what local fishermen, local boat captains, local residents had been calling it for years. Years during which official America was largely looking the other way. The island was the ultimate expression of Epstein's architectural philosophy. Create an environment so controlled, so remote, so entirely as that anyone who entered it had implicitly ceded their connection to the ordinary world. The water was the wall, and on the side of that wall, Jeffrey Epstein was, for all practical purposes, the law. Here is a question that sounds simple but isn't. How does a man with no verified client list, no publicly demonstrated financial track record, and a background that doesn't withstand serious scrutiny, how does that man end up at dinner with heads of state? How does he end up in the address books of sitting presidents? How does he end up advising a major research university on its scientific agenda? Flying foreign dignitaries on his plane? Hosting physicist celebrities and royalty at his home in the same week? The answer is both simpler and more disturbing than most people expect. Jeffrey Epstein understood something fundamental about the very top tier of human society. At that level, access is the currency, not money. Everyone at that level has money. The thing that matters, the thing that creates real social capital, is the sense that you are connected to something rare, that you are in a room that most people cannot enter, that the person sitting across from you has a relationship with other people that you want to be close to. Epstein engineered that perception with the precision of an architect. He cultivated scientists first. His relationship with Harvard, where he donated $6.5 million between 1998 and 2003, and later made a $50 million pledge that was processed after his death amid significant controversy, gave him proximity to some of the most celebrated intellectual minds in the world. He was photographed with theoretical physicists. He hosted dinners at which Nobel laureates were seated next to film directors and financial titans. The effect was deliberate. When a prince sees a Nobel laureate at the table, he assumes the host is a man of substance. When a CEO sees a senator, he assumes the host is plugged into power. When a scientist sees a billionaire, he assumes the host can fund his research. Everyone in the room is impressed by someone else in the room, and at the center of all of it, always reliably with a quiet smile, is Jeffrey Epstein. His relationship with Ghislaine Maxwell, the British socialite and daughter of disgraced media mogul Robert Maxwell, was central to this operation. Maxwell had grown up in genuine European aristocracy, or at least its edges. She had connections to royal households. She had access to social circles that American money, no matter how vast, could not simply purchase entry into. And she became Epstein's most crucial social architect, the person who could walk into a room of British nobility and make a phone call that would be returned, who could introduce Epstein as someone worthy of trust in a world that was deeply suspicious of American financiers it hadn't heard of. Their personal relationship, romantic, according to multiple accounts, gave Maxwell a stake in Epstein's success that went beyond the professional, and her role in his operation, as prosecutors would eventually document, went far beyond social introductions. But in the social universe they co-created, Maxwell was the key that opened the most prestigious doors. Through Maxwell, Epstein gained a relationship with Prince Andrew, the Duke of York, Queen Elizabeth's second son. Andrew would later claim, in a BBC interview of such catastrophic awkwardness that it effectively ended his public life, that he had simply been a casual acquaintance of Epstein's, that he had visited Epstein's various properties simply as a house guest, and that he had no knowledge of any wrongdoing. The photographs told a different story. The flight logs told a different story. The testimony of victims told a different story. Through his scientific philanthropy, Epstein cultivated relationships with figures like the late Marvin Minsky, the pioneering AI researcher at MIT, with the physicist Stephen Hawking, who visited Little St. James, with Lawrence Krauss, the theoretical physicist, and with a network of academic and intellectual figures whose association with Epstein gave him a veneer of intellectual seriousness that was, by multiple accounts, entirely manufactured. MIT's Media Lab accepted funding from Epstein even after his 2008 conviction for soliciting prostitution from a minor, a fact that, when emerged publicly in 2019 largely through reporting of Ronan Farrow in The New Yorker, triggered resignations, investigations, and a reckoning within the institution that continues to this day. The lab's director, Joy Ito, resigned. Internal documents showed that the lab had gone to deliberate lengths to conceal the source of some of the donations. Harvard, similarly, found itself in the uncomfortable position of explaining why it had accepted money from a convicted sex offender and what exactly its institutional relationship with Epstein had looked like over the years during which that money flowed. The network also included former President Bill Clinton, who flew on Epstein's private plane multiple times, according to flight logs, a fact that was acknowledged by Clinton's office, which stated that the former president had traveled on the plane 4 times, though the logs appear to indicate more trips than that. Clinton has denied ever visiting Little St. James or Epstein's Palm Beach estate. It included former President Donald Trump, who described Epstein in a 2002 New York Magazine profile as a terrific guy who liked beautiful women on the younger side. Trump has since stated that he banned Epstein from his Mar-a-Lago property years before the investigation, and that he was never involved in any of Epstein's activities. It included dozens of other names, politicians, financiers, entertainers, academics, who have either denied any wrongdoing, acknowledged knowing Epstein socially while denying knowledge of his crimes, or declined to comment entirely. What the network represented, at its most fundamental level, was the answer to a question that investigators kept asking: how was it allowed to go on for so long? And the answer was, because the people who had the power to stop it were, in many cases, connected to the man who was doing it. This is the section that matters most, because in the avalanche of revelations, in the speculation about famous names and shadowy networks and geopolitical implications, it is the easiest thing in the world to lose sight of what this case is actually about. It is about girls. Young girls, many of them teenagers, some as young as 14 years old according to testimony and court documents. Girls who came from circumstances that made them vulnerable. Girls who were targeted not randomly, but deliberately, selected by a system that had been designed with horrifying precision to find the young, the financially desperate, the emotionally isolated, and the naive. Girls whose lives were changed in ways that cannot be undone. The recruitment system that prosecutors documented in the Palm Beach investigation, and that was later confirmed and expanded upon in federal proceedings, worked like this. Epstein employed a network of recruiters, young women themselves in many cases, who were paid to find other young women and bring them to Epstein's properties under the guise of paid massage work. Girls from local schools. Girls from the neighborhoods around his Palm Beach estate. Girls who were told they would be paid well for simple, legal work. When they arrived, the situation was not what they had been told it would be. According to testimony from dozens of victims, the massages quickly became something else entirely, something for which no young girl had given meaningful consent, and something for which no amount of money offered after the fact could constitute retroactive agreement. The recruiters, in many cases, had been victims themselves before they became recruiters. That cycle of victimization leading to complicity, of girls who have been trapped and being used to trap other girls, was one of the most psychologically devastating aspects of the entire structure. It made victims feel responsible. It made them feel complicit. And it made many of them reluctant to come forward because they feared they would not be believed, or worse, that they would be treated as perpetrators rather than as the victims of a system that had been specifically designed to exploit their own victimization. One name above all others has become the public face of the survivor community, Virginia Roberts Giuffre. Giuffre, who was known as Virginia Roberts at the time of her recruitment, was 15 years old when she was first approached at Mar-a-Lago in Palm Beach, where she worked as a locker room attendant. According to her account, Ghislaine Maxwell approached her, expressed interest in her, and offered her an opportunity to train as a masseuse for an important client. That client was Jeffrey Epstein. Giuffre has testified in depositions and in court filings and in extensive public interviews that she was trafficked by Epstein and Maxwell from the age of 15. She has stated that she was sexually abused by Epstein repeatedly. She has stated that she was directed by both Epstein and Maxwell to have sexual contact with a number of high-profile individuals, including, in her testimony, Prince Andrew, who has categorically and repeatedly denied her allegations. Giuffre pursued civil litigation against both Epstein's estate and, ultimately, against Prince Andrew himself, a lawsuit that was settled in 2022 for an undisclosed sum, with Andrew neither admitting nor denying liability. The settlement was described by many legal observers as extremely unusual and as suggesting that the calculus of continued litigation was not favorable to Andrew. But Giuffre's story, while most publicly visible, represents only one thread in a tapestry of documented abuse that involved dozens of young women and girls over a period that spanned, according to prosecutors, more than a decade. Courtney Wild was another victim who has spoken publicly. She was recruited at the age of 14 from a local school in Palm Beach. She has described with devastating precision the process by which she was manipulated, the initial payment, the normalization, the escalation, and the psychological mechanisms by which she was made to feel that what was happening to her was something she had chosen. Michelle Licata, Chauncey Davies, Sarah Ransom, Annie Farmer, Maria Farmer, who was actually one of the very first people to report Epstein to the FBI in 1996, nearly a decade before Palm Beach police would open their investigation. Farmer has stated that when she made her report, the FBI agent she spoke to seemed uninterested, that the call she made into the official system of justice, a call that could potentially have stopped years of additional abuse, went essentially nowhere. Think about that. A woman contacts the FBI and makes a report about Jeffrey Epstein. The investigation that would eventually lead to a federal indictment doesn't happen for more than 2 decades. 2 more decades of victims. The women who have come forward are, in every measurable respect, credible. Their accounts are consistent with one another in their specific details in ways that independent fabrication cannot explain. They have been subjected to intense cross-examination by some of the most expensive defense attorneys that money could retain. They have faced public skepticism, online harassment, and the particular cruelty that American culture reserves for women who accuse powerful men of serious crimes. They have kept telling the truth anyway, and it is their testimony, their voices, their specific documented accounts that form the evidentiary foundation of everything else in this story. Not theories, not speculation, not the inferences drawn from famous names in flight logs. The testimony of the people who were in those rooms, on those tables, on that island, is the center of this case. Everything else radiates outward from them. The story of how Jeffrey Epstein first came to the attention of law enforcement is a story that tells you nearly everything you need to know about how power protects itself. It began in March of 2005. A Palm Beach woman contacted local police with a report that her 14-year-old stepdaughter had received $300 in exchange for giving massage to a man at a home on El Brillo Way in Palm Beach. The woman's account of what her stepdaughter described happening during that massage constituted, on its face, a serious crime. Palm Beach police opened a case. Detective Joseph Reed Carey was assigned to lead the investigation. What Reed Carey found, over the months of investigation that followed, was not an isolated incident. It was a system. He found victim after victim, most of them teenagers from local schools and local neighborhoods, who described nearly identical experiences. The recruiting, the transportation, the arrival at the El Brillo Way house, the initial pretense of legitimate massage work, the escalation, the payment, the instruction in many cases to bring friends. By the time Reed Carey's investigation was complete, he had documented more than 30 victims. He had gathered physical evidence. He had built what multiple legal analysts who later reviewed the file described as a strong, prosecutable case. He submitted his findings to the Palm Beach County State Attorney's Office, which under normal circumstances would have initiated the prosecution. Nothing happened. The state attorney's office declined to prosecute. Palm Beach Police Chief Michael Ryder, whose department had built the case, took the extraordinary step of going outside the normal chain of command. He referred the case directly to the FBI and the U.S. Attorney's Office for the Southern District of Florida. The federal investigation that followed was, by all documented accounts, even more extensive than the Palm Beach investigation. FBI agents identified more victims. They gathered more evidence. They developed a case that according to multiple former prosecutors who have reviewed the publicly available record, was among the strongest sex trafficking cases they had seen. The recommended charges: multiple counts of federal sex trafficking. The potential sentence: life in prison, or something very close to it. And then something happened that has never been fully explained. The U.S. Attorney for the Southern District of Florida at the time was a man named Alexander Acosta. He was a Harvard Law graduate, a former clerk to Supreme Court Justice Samuel Alito, and a man with a distinguished legal pedigree who would go on to serve as Secretary of Labor in the Trump administration. In 2007, Acosta entered into negotiations with Epstein's legal team, a team that, it should be noted, included some of the most expensive and well-connected defense attorneys in the country, including Alan Dershowitz and former independent counsel Kenneth Starr. What emerged from those negotiations was a document that, when it became public a decade later, would be described by legal experts across the political spectrum in terms ranging from extraordinary to outrageous. It was called a non-prosecution agreement. The non-prosecution agreement signed in 2008 between Jeffrey Epstein and the U.S. Attorney's Office for the Southern District of Florida is one of the most remarkable documents in the modern history of American criminal justice. Here is what it did. In exchange for Epstein pleading guilty to 2 state charges, solicitation of prostitution and solicitation of prostitution from a minor, both Florida state crimes that were considerably less serious than what the federal investigation had developed, the federal government agreed not to prosecute Epstein on any federal charges, not just the charges they had already identified, any federal charges related to any of the conduct that had been investigated. The agreement also, in a provision that was specifically designed to avoid triggering legal requirements about victim notification, granted immunity to any potential co-conspirators. The agreement named 4 specific women, but the immunity it conferred was, by the agreement's own language, potentially far broader than those 4 names. Under the agreement, Epstein would serve 18 months in county jail, not federal prison, county jail. He would be registered as a sex offender. He would pay restitution to his identified victims. He served 13 months, not 18, 13. During those 13 months, under a work release arrangement that was approved by local authorities and that would later become the subject of its own federal investigation, Epstein was permitted to leave the jail facility for up to 12 hours a day, 6 days a week, to work from his Palm Beach office. He was not in prison. He was barely in jail. He was, in almost any meaningful sense of phrase, a free man who happened to sleep in a county detention facility. And the victims, the 30-plus identified victims whose abuse had formed the foundation of the investigation, whose testimony had built the case, were not told about the deal before it was finalized. That was not an oversight. That was a choice. The Crime Victims' Rights Act, a federal law passed in 2004, specifically requires that federal prosecutors notify crime victims of plea negotiations and give them an opportunity to be heard before agreements are finalized. It is not an optional provision. It is a legal requirement. The U.S. Attorney's Office, in the handling of the Epstein NPA, did not comply with this requirement. Prosecutors from that office later argued that the act did not apply because no federal charges had been filed. Federal judges who reviewed that interpretation were not uniformly persuaded. Courtney Wild, one of the identified victims, became the lead plaintiff in a lawsuit challenging the NPA's legality under the Crime Victims' Rights Act. In 2019, U.S. District Judge Kenneth Mara issued a ruling that found that the government had violated the rights of victims by failing to notify them. He did not vacate the NPA at that time, but his ruling was a documented, judicial finding that the process by which the agreement was reached had been unlawful. The question that hung over all of it, the question that Acosta was never able to answer in a way that satisfied anyone, was why? Why did a federal prosecutor with a strong case against a man with dozens of documented victims choose to offer a deal this favorable? When Acosta appeared before the Senate in 2019 for his confirmation hearing as Labor Secretary, he was asked about the Epstein deal. His explanation, that the deal had been driven by concerns about the strength of the evidence and the risk of losing at trial, struck many legal observers as unconvincing given the documented scope of the investigation. There was one statement Acosta made years later in a meeting with Trump transition officials that was reported by the Miami Herald, and that has never been officially confirmed or denied with full context. According to that report, Acosta told the transition team that he had been told to back off Epstein, that Epstein belonged to intelligence and was above his pay grade. That claim, intelligence, is something we will return to. Acosta resigned as Labor Secretary in July 2019, shortly after the new federal indictment of Epstein became public. He insisted his resignation was not an admission of wrongdoing. By 2018, the Epstein NPA had been public knowledge for a decade. It had been written about. It had been criticized. Legal commentators had picked it apart. And then the news cycle had moved on, because that is what news cycles do. Jeffrey Epstein lived his life. He traveled on his planes. He visited his properties. He attended dinners with scientists and financiers and royalty. He was a convicted sex offender on the Florida registry. But he was also a billionaire who operated as though the conviction were a minor administrative inconvenience rather than a marker of what he actually was. And then Julie K. Brown of the Miami Herald started making phone calls. Brown is an investigative reporter. She is not a celebrity journalist. She is not a cable news personality. She is the kind of journalist who spends months and months and months finding people who do not want to be found, building trust with sources who have every reason not to trust a reporter, reconstructing events through document after document after document, and then sitting with an editor and saying, "I have it. This is real. Let's publish." In November 2018, the Miami Herald published Brown's investigation, a 3-part series titled Perversion of Justice. It was among the most consequential pieces of investigative journalism published in the United States in recent memory. Brown had found victims, not one or two, dozens. She had found women and girls who had never spoken to the media before, who had never spoken publicly about what had happened to them at all. She had found them scattered across Florida and beyond, many of them still carrying the weight of what they had experienced in silence, many of them not knowing that there were dozens of others with nearly identical stories. And she had gotten them to talk. Their accounts, published in the Miami Herald with detail and specificity and documentation, did something that years of legal filings and court proceedings had failed to do. They made it impossible to look away. They gave faces and names and voices to what had previously been somewhat abstract to much of the public. Victims, described in legal documents, identified only by initials. Brown also documented, with extraordinary thoroughness, the process by which the NPA had been negotiated and what it had actually cost the women involved. She traced the relationships between Epstein's legal team and figures in the Justice Department. She documented the work-released arrangement. She published accounts from victims who described receiving, for the first time from a journalist rather than prosecutor, what felt like genuine acknowledgement that they had been wronged not just by Epstein, but by the system that was opposed to protect them. The series went viral in a way that legal filings rarely do. It was read by millions of people. It was cited in congressional testimony. It was by multiple accounts. A significant factor in the decision by the U.S. Attorney's Office for the Southern District of New York, a different jurisdiction from the one that had negotiated the NPA, to revisit the federal case against Epstein. Brown's investigation won the George Polk Award for Legal Reporting. It won the IRA Award. It was recognized across the profession as exactly what it was: the kind of journalism that exists to hold power accountable when every other mechanism has failed. It is worth pausing here to acknowledge something. The Miami Herald is a regional newspaper. Julie K. Brown is one journalist. The story she broke had been legally documented, had been the subject of federal investigation, had involved dozens of identified victims, and had resulted in a plea agreement so extraordinary that it had been challenged in federal court. And it took a regional newspaper and one determined reporter to make the country pay attention. What does that tell you about every other institution that had access to this information and chose, for whatever reason, not to pursue it? July 6, 2019. Jeffrey Epstein landed at Teterboro Airport in New Jersey aboard his private plane, returning from Paris. Federal agents were waiting for him on the tarmac. He was arrested, taken into custody, transported to the Metropolitan Correctional Center in Lower Manhattan, where he was held without bail pending trial. The indictment unsealed by the Southern District of New York was, in the language of criminal justice, comprehensive. 2 counts: sex trafficking of minors and conspiracy to engage in sex trafficking of minors. The government alleged that Epstein had operated a sexual abuse network involving dozens of underage girls, primarily between 2002 and 2005, though the investigation encompassed a broader timeline. The potential sentence was 45 years. For the first time in his life, Jeffrey Epstein was facing the full weight of federal prosecution, without the safety net of a deal negotiated at a level he could apparently control. The legal team he assembled was formidable, but this time the jurisdiction was New York. This time, the political climate had been transformed by the Miami Herald investigation. This time, the victims were organized, represented by their own attorneys, vocal and determined in a way that had not been possible under the circumstances of the 2008 deal. On July 18th, Judge Richard Berman denied bail. He found that Epstein represented a danger to the community and a flight risk of the highest order, a man who had private planes, overseas properties, foreign bank accounts, and decades of experience moving across international boundaries with ease. The idea of releasing him on any bail arrangement that could be considered secure was, the judge found, unreasonable. Epstein was remanded to the MCC. His legal team filed appeals. They argued for home detention with electronic monitoring at his Manhattan townhouse, offering a bail package reportedly worth up to $100 million. The government opposed. The judge held. For those who had spent years watching Epstein operate beyond the reach of accountability, the sight of him in federal detention, in the same facility that had housed El Chapo, that had housed Ramzi Youssef, felt like something close to justice beginning to take shape. And then came July 23rd. Epstein was found in his cell in a semi-conscious state with marks on his neck. The official determination was that the incident was either a suicide attempt or an assault by his cellmate, Nicholas Tartaglione, a former police officer accused of murder, who was housed in the same cell. Tartaglione's attorneys have denied that he attacked Epstein. The truth of what happened that night has never been definitively established by any official investigation. What happened next is where the story enters territory that reasonable people, not conspiracy theorists, not fringe commentators, but career law enforcement officers, federal judges, and legal scholars have described as simply inexplicable, despite the July 23rd incident. Jeffrey Epstein was taken off suicide watch. His cellmate was transferred. No replacement cellmate was assigned. The two guards designated to check on him every 30 minutes both fell asleep simultaneously during their shift. Both of them. This was documented. This happened for approximately 3 hours, according to the official timeline. No one checked on Jeffrey Epstein. At approximately 6:30 a.m. on August 10th, he was found unresponsive in his cell. He was pronounced dead at New York Presbyterian Hospital, Lower Manhattan, at 7:36 a.m. The official cause of death: hanging. The official ruling: suicide. Let's be very specific here, because the details matter enormously, and the details are genuinely strange. Dr. Michael Baden, a forensic pathologist of international reputation who has worked on some of the most high-profile cases in American history, including the JFK assassination review and the O.J. Simpson case, was hired by Epstein's brother Mark to observe the autopsy conducted by the New York City Medical Examiner. Dr. Baden's findings were not consistent with the official ruling of suicide by hanging. He found multiple fractures in Epstein's neck, specifically fractures in the hyoid bone and both sides of thyroid cartilage. Baden stated publicly and clearly that this pattern of injury is more consistent with homicidal strangulation than with suicide by hanging, particularly the kind of hanging possible in the conditions of a jail cell, where the height from which a person can suspend themselves is severely limited. The official medical examiner, Dr. Barbara Sampson, ruled the death a suicide. She acknowledged that the injuries were unusual for a suicide by hanging, but maintained that her overall assessment of the evidence supported that conclusion. The disagreement between these two forensic pathologists is not a fringe phenomenon. It is a documented scientific disagreement between credentialed experts, one hired by the official system and one hired independently, about the physical evidence from the most consequential prison death in recent American history, and it has never been formally resolved. The Department of Justice's Office of Inspector General opened an investigation into the circumstances of Epstein's death. That investigation has dragged on for years. As of the time of this writing, No final public report attributing clear fault or reaching definitive conclusions has been released in a way that has satisfied independent observers. The two guards, Tova Noel and Michael Thomas, were indicted on federal charges of falsifying prison records and lying to investigators. They were not charged with any crime related to Epstein's death itself. Their case went through various procedural stages, and the Justice Department eventually moved to drop the charges, citing the difficulty of proving their mental state and the impact of the COVID-19 pandemic on the case timeline. They were not convicted of anything. The warden of the MCC at the time of Epstein's death, Lamine Ndiaye, was reassigned. The MCC itself has since been closed in 2021 amid conditions that the Department of Justice described as deplorable following an unrelated escape by two inmates. The closing of the facility itself has been noted by some observers as making a full independent forensic accounting of what happened on August 10th even more difficult. There are additional details that do not fit neatly into either the official suicide narrative or any specific alternative theory, and it is worth laying them out plainly. According to multiple reports, Epstein's wrists bore no marks consistent with having used a ligature, marks that typically appear in suicide by hanging as a person instinctively reaches for the object around their neck. These reports have been disputed by others, and the official record is ambiguous. The malfunction of the security cameras in the vicinity of Epstein's cell has been acknowledged by the Bureau of Prisons. The exact nature of the malfunction, whether it was mechanical failure, human intervention, or something else entirely, was never fully and publicly explained. The prison itself, the MCC, had a well-documented history of failures, understaffing, equipment malfunctions, poor oversight. Critics of the conspiracy narrative argue that the combination of circumstances surrounding Epstein's death is more consistent with institutional dysfunction than with orchestrated foul play. That may well be true, but consider what institutional dysfunction means in this specific context. It means that the most high-profile federal prisoner in America, a man whose survival was essential to one of the most significant prosecutions in modern American history, was failed by every system designed to keep him alive. Not one, every single one. Whether that is conspiracy or catastrophic incompetence is a question that remains genuinely open. What is not open is a documented reality. Epstein died before trial, before testimony, before the full weight of federal prosecution could play out in the courtroom. And every person he might have named, every network he might have exposed, every deal he might have been pressured to reveal in exchange for a plea, all of that died with him. On July 2nd, 2020, the FBI located Ghislaine Maxwell at a property in Bradford, New Hampshire, where she had been living under a degree of concealment, and arrested her. The announcement of her arrest felt, to many people who've been following the case, like the first significant legal accountability since Epstein's death. Ghislaine Noel Marion Maxwell was born on December 25, 1961, in Maisons-Laffitte, France. She was the ninth child of Robert Maxwell, the British media mogul, newspaper baron, and member of Parliament who controlled a publishing empire and whose death in 1991, when he fell from his yacht in the Atlantic Ocean under circumstances that were also officially ruled accidental, also never entirely lost a shadow of alternative theories. Ghislaine grew up in a world of extraordinary privilege and extraordinary pressure. Her father was domineering, brilliant, and deeply unpredictable, his death, and the revelation afterward that he had looted hundreds of millions of pounds from his employees' pension funds, leaving thousands of pensioners facing financial devastation, upended everything the Maxwell children had understood about their family standing. Ghislaine came to New York, connected with Epstein, and began what would become the most consequential relationship of her adult life. At trial, which began in November 2021 and concluded in December that year, the government presented extensive testimony from 4 women who described, in specific detail, being groomed and trafficked by the Epstein-Maxwell operation. The witnesses testified about Maxwell's direct, active, knowing role in recruiting young girls, in normalizing sexual contact with Epstein, in participating in abuse, and in helping to maintain the operation's secrecy. Maxwell's defense argued that she was being scapegoated, that the government was prosecuting her because Epstein was dead, and that she was being held responsible for conduct that was either not proven or not hers. The jury was not persuaded. On December 29, 2021, Ghislaine Maxwell was convicted on 5 of the 6 counts against her, including the most serious, sex trafficking of a minor. On June 28, 2022, she was sentenced to 20 years in federal prison. She is currently serving that sentence at FCI Tallahassee. Maxwell's conviction was, legally speaking, a significant milestone. It was the first criminal conviction of a person directly connected to the Epstein operation, and it validated, through the judicial process, what the victims had been saying for years. But Maxwell's conviction also reopened a question that has never gone away. She did not cooperate with the government. She did not provide testimony implicating others. She did not, as many of the victims and their advocates had hoped, use her intimate knowledge of the network she and Epstein had built, the names she knew, the events she had witnessed, the documentation she may have had access to, as leverage for a cooperation agreement, whether that decision reflected loyalty, legal strategy, or the calculation that certain names were simply too dangerous to name, is something only Maxwell knows. She has given several interview requests from prison. She has, according to reports, maintained contact with a small circle of associates. Whether she will eventually speak fully and publicly about what she knows is one of the open questions that hangs over the entire case. There is a document that has been in and out of court proceedings, partially released, partially analyzed, and endlessly discussed, a document that, depending on whom you ask, either proves or fails to prove a staggering array of claims about the Epstein network. It is a flight manifest log from Jeffrey Epstein's private aircraft. The logs have been the subject of legal battles over privacy, relevance, and the rights of individuals named in them who claim they were innocent passengers unaware of any criminal activity. Some portions have been released through court proceedings. Others remain sealed or disputed. What the publicly available portions of the logs document is a remarkable catalog of the world's most prominent people traveling aboard Epstein's planes, to his various properties, between international destinations, and in patterns that, in retrospect, map onto the geography of his operation in suggestive ways. Former President Bill Clinton's presence on the aircraft has been documented by his own office, which acknowledged 4 trips, a number that the logs themselves appear to suggest may have been an undercount. Clinton has consistently stated that he was unaware of any wrongdoing and that his trips were related to charitable work through the Clinton Foundation. He has denied ever visiting Little St. James or Epstein's Palm Beach home. Prince Andrew's presence on aircraft and at Epstein properties is documented in photographs, in victim testimony, and in flight records that have been discussed in open court proceedings. Andrew has denied the allegations of Virginia Jeffrey, which include a claim that she was directed to have sexual contact with him when she was 17. Andrew paid a settlement in a civil suit brought by Jeffrey. Kevin Spacey, the actor, was photographed with Epstein and has been identified in various accounts as having visited Epstein's properties, including a trip to Africa on a plane associated with Epstein, accompanied by Clinton. Spacey faces his own separate legal proceedings related to different accusations. Alan Dershowitz, the Harvard Law professor emeritus and celebrity attorney, who was part of Epstein's 2008 defense team, is named in allegations by Virginia Jeffrey that he had sexual contact with her when she was a minor. Dershowitz has denied these allegations with extraordinary vehemence and has pursued legal action against Jeffrey and others he claims defamed him. He maintains that his name in any documents simply reflects his role as Epstein's attorney. The publication in January 2024 of a large tranche of previously sealed documents related to the civil litigation brought by Virginia Jeffrey against Ghislaine Maxwell produced a wave of new names and new details that cycled through the media before, in many cases, being contextualized by the important clarification that appearing in a lawsuit's documents does not constitute a finding of guilt or even an allegation of wrongdoing in every case. Some names appeared because they were accused of abuse. Some names appeared because they were listed as witnesses. Some names appeared because they had been questioned. Some names appear because they have been mentioned in passing in emails or testimony in ways that reflected social connection rather than criminal conduct. The media coverage of those documents, in many cases, failed to make those distinctions clearly, a failure that produced both legitimate public interest in genuine findings and unfair collateral damage to individuals whose involvement was far less sinister than the headlines implied. What the documents did establish, beyond a question of any individual's culpability, was a breadth of the social world that Epstein had constructed. It was a world in which some of the most recognizable names in global politics, entertainment, and finance had at minimum sat in the same room with him, flown on his plane, attended his dinners, or engaged in correspondence that reflected a relationship of some warmth. None of that is a crime. Knowing a criminal is not a crime. Attending a dinner party at a criminal's house is not a crime. Flying on a private plane owned by a criminal without knowing that the owner is a criminal is not a crime. What the flight logs and the documents do, taken together, is paint a picture of a world in which extraordinary proximity to serious criminal conduct was distributed across the highest levels of global society. And they leave the question, a question that cannot be definitively answered from the logs alone, of how many of those people knew or should have known or suspected or chose not to ask. This is the part of the story that sounds like a thriller, the part that, in a movie, would be the third act revelation, the part that serious, credentialed journalists have pursued and found, not a complete answer, but a trail of evidence that is difficult to explain away. The question, was Jeffrey Epstein operating as an intelligence asset? Let's start with what is documented. Epstein had a relationship at various points in his life with individuals who had provable connections to intelligence agencies. This is not speculation. It is a matter of public record that some of the people in Epstein's orbit had backgrounds in intelligence work. Ghislaine Maxwell's father, Robert Maxwell, was widely believed and has been described in credible journalistic and intelligence community accounts to have had relationships with multiple intelligence agencies, including Israeli intelligence. His death on a yacht in international waters produced official rulings of accidental drowning, but intelligence community observers have continued to regard the circumstances as, at minimum, ambiguous. Ari Ben-Menash, a former Israeli intelligence operative who has been a controversial and not always reliable source on various intelligence-related stories, has claimed in interviews that both Robert Maxwell and Jeffrey Epstein worked for Israeli intelligence, that Epstein's operation, including the gathering of compromising information on powerful men, was run on behalf of Israeli intelligence. These claims have not been verified through independent documentary evidence and should be regarded as allegations from a source with a history of contested claims. However, and this is the important part, the logic of what Epstein's operation accomplished, if viewed through an intelligence lens, is coherent in a way that is difficult to dismiss entirely. An operation that places powerful men in compromising situations, that creates photographic or video documentation of those situations, that then uses that documentation as leverage, whether to extract money, to gain access, to ensure cooperation, or simply to maintain a hold over the powerful, is not a new concept in the history of espionage. It is called a honey trap. It is one of the oldest tools in the intelligence trade book. The cameras that investigators found throughout Epstein's properties, in his Manhattan townhouse, described in court documents and by investigators who searched the property, are one of the most suggestive physical elements of the entire case. If the purpose of those cameras was simply Epstein's personal record-keeping, that is disturbing enough. But if the recordings those cameras produced were shared with or produced on behalf of a third party, a government agency, a private intelligence operation, a network of individuals interested in maintaining leverage over the powerful, the implications are almost too large to fully contemplate. Former Senator John Tower, a senior government official, was photographed at Epstein's New Mexico ranch in the 1980s. The CIA's Inspector General has reportedly conducted internal reviews related to aspects of the Epstein case, though the results of any such review have not been publicly released. Robert Maxwell, Ghislaine's father, reportedly had access to Promis software, a powerful intelligence database that had been the subject of one of the most Byzantine espionage scandals of the 1980s. The question of whether that software or anything like it had relevance to the Epstein operation is one that investigators have noted without resolving. Stephen Hoffenberg, a convicted fraudster who has claimed to have worked closely with Epstein in the 1980s, stated in interviews before his death in 2022 that Epstein had been an intelligence asset, that his entire financial and social operation was structured to benefit a network of intelligence interests. Hoffenberg was not an objective or unimpeachable source, but his account, combined with the other threads of this particular part of the story, has led serious journalists to continue pulling on the intelligence angle rather than dismissing it. The most significant documented piece of this puzzle remains a statement attributed to Alexander Acosta, made, according to reporting, to Trump transition officials in 2016, that Epstein was connected to intelligence and was above his pay grade. If that statement was made, and if it was accurate, it would represent perhaps the most important and most damning single piece of information in the entire case. If Epstein was an asset of any intelligence agency, domestic or foreign, and if the NPA was negotiated in part because of that relationship, then the deal was not merely an act of prosecutorial favoritism in exchange for money and social pressure. It was an act of state protection of a predator. And the victims were not just failed by one corrupt deal. They were failed by the machinery of national security itself. The story of Jeffrey Epstein is not only the story of one man's crimes. It is a story of institutions, many of them, across many years, many jurisdictions, that should have stopped him and didn't. Let's go through them. Palm Beach Police Department. To their credit, they opened the investigation. Detective Reed Carey built a strong case. But the department's broader institutional response, including the early decision to maintain confidentiality that may have limited interagency cooperation, reflected a system that had not been designed to handle a case of this complexity and this sensitivity. Palm Beach County State Attorney declined to prosecute following the initial investigation. No public explanation has ever fully accounted for this decision. United States Attorney's Office, Southern District of Florida, under Alexander Acosta, negotiated the NPA. The victims were not notified as required by law. The deal has been described by legal scholars as indefensible given the evidence available. A federal judge found that the victims' rights had been violated. The FBI received a report from Maria Farmer in 1996. For whatever reason, insufficient evidence, competing priorities, assessment of credibility, the report did not result in an investigation that materially altered the timeline of Epstein's conduct. The Bureau of Prisons failed to maintain basic suicide watch protocols for the most high-profile prisoner in federal custody, lost camera footage, allowed both guards to fall asleep simultaneously, failed to replace Epstein's cellmate, allowed the conditions to exist under which he either took his own life or was killed, depending on what actually happened. Harvard University accepted $6.5 million from Epstein after his 2008 conviction, named a research program after him, maintained a relationship with him that its own review described as far closer than it should have been given his criminal record, returned the money only after public pressure following his 2019 arrest. MIT Media Lab accepted donations from Epstein post-conviction. According to internal documents published by The New Yorker, went to deliberate lengths to conceal the source of the donations, labeling them as anonymous to avoid the reputational complications of association with a registered sex offender. The lab's director resigned. MIT subsequently commissioned an independent review that found systemic failures in its donation review processes. J.P. Morgan Chase maintained Epstein as a client for years after his 2008 conviction, processing transactions that prosecutors and civil plaintiffs allege were related to his sex trafficking operation. In 2023, J.P. Morgan settled a lawsuit brought by the government of the U.S. Virgin Islands for $75 million and a separate civil suit brought by victim Jane Doe for $290 million without admitting liability. Internal emails produced during litigation suggested that senior executives at the bank, including former executive Jess Staley, had knowledge of Epstein's reputation and maintained a relationship nonetheless. Staley has denied wrongdoing. Deutsche Bank also maintained a banking relationship with Epstein after his 2008 conviction, reached a $75 million settlement with the New York State Department of Financial Services in 2020 over its failure to flag suspicious transactions in Epstein's accounts. The bank acknowledged that it should not have taken him as a client and that its internal controls had failed. The U.S. Virgin Islands. Epstein was one of the largest private landowners in the territory. His companies were granted significant tax benefits under an economic development program. The territory's government later filed suit against Epstein's estate and against J.P. Morgan and Deutsche Bank, alleging that his financial institutions had helped to move money related to his trafficking operation through their networks. Each of these institutional failures, taken individually, might be explainable by incompetence, by regulatory gaps, by the ordinary limitations of bureaucratic systems. Taken together, across 3 decades, across multiple jurisdictions, across institutions ranging from federal law enforcement to elite universities to global financial institutions, they describe something that goes beyond ordinary dysfunction. They describe a world in which money and social connection could purchase, if not complicity, then a remarkably consistent pattern of averted eyes. In late 2023 and early 2024, a judge overseeing civil litigation related to the Epstein case ordered the release of a large collection of previously sealed documents. The documents have been gathered in connection with the lawsuit brought by Virginia Giuffre against Ghislaine Maxwell. Settled in 2017, their release, in tranches over several weeks, produced one of the most intense and, in some ways, most confused media cycles of recent years. Here is what those documents actually contained and what they did not contain. They contained deposition testimony from multiple individuals, including depositions of people who have been questioned about their knowledge of Epstein's activities, their presence at his properties, and their observations of his interactions with young women. Some of this testimony was explosive. Some of it was mundane. Some of it named individuals in connection with allegations that were serious. Some of it mentioned individuals in passing, in ways that reflected connection but not criminality. They contained emails, exchanges between Maxwell and Epstein, between Maxwell and various associates, and between individuals in her orbit that provided a window into the day-to-day operations of a world that had previously been described only through the accounts of victims. The emails revealed a social environment of stunning casualness, in which abuse, by the time of these communications, had been normalized to the point that it was managed with the administrative efficiency of a business operation. They contained testimony from Jean-Luc Brunel, a French modeling agent who was described by multiple victims as a recruiter for Epstein, a man who used his position in the modeling industry to identify and gain access to young women, who could then be funneled into Epstein's network. Brunel was arrested in France in 2020 and died in a French prison in February 2022 while awaiting trial. Also officially ruled a suicide, in circumstances that also generated questions. The documents contain references to a significant number of prominent individuals. In some cases, individuals directly implicated by victims in specific acts of abuse. In others, Individuals mentioned peripherally in ways that reflected social connection rather than criminal conduct. The distinction is critical, and in the media coverage of these releases, it was frequently blurred in ways that produced both legitimate journalism and significant unfairness. To people whose connection to Epstein was social rather than criminal, what the documents, taken in full and read carefully, establish is this: Epstein's network was real, it was large, it was global, and it operated for decades. The mechanisms of recruitment, transportation, and access were documented. The pattern of abuse was consistent and corroborated. The social infrastructure that allowed the network to function, the houses, the planes, the island, the dinner parties, the philanthropic veneer, was precisely what it appeared to be: cover for an operation of almost industrial scale. And the question of how many of the network's prominent members were aware of its criminal nature, of the ages of the girls involved, of the absence of consent that made what was happening not massages but assault, remains in many individual cases unanswered in any legally definitive way, because the man who could have answered it is dead. This is where many people want a simple answer. They want this to be a story about one political party. They want to be able to say, this is what those people do. This is what that ideology produces. The documented reality refuses to cooperate with that desire. Jeffrey Epstein's network crossed every political line that exists in American public life. He had connections to powerful Democrats and powerful Republicans. He had connections to the Clinton world and to the Trump world. He had connections to politicians who occupied opposite ends of every major policy debate in American life, and who had in common only their proximity to money and power, which Epstein supplied in abundance. This is not an argument for false equivalence. It is a factual statement about the geography of the network. Former President Clinton has acknowledged flying on Epstein's plane. He has denied visiting Epstein's island or home. Whether those denials are complete or partial is something the public record does not resolve with certainty. Former President Trump knew Epstein socially. His 2002 quote about Epstein liking women on the younger side is documented in New York Magazine. He has stated that he cut off his relationship with Epstein and banned him from Mar-a-Lago after a property dispute involving a minor, a claim that some contemporaneous accounts appear to partially support, though the full context has been disputed. He has denied any involvement in Epstein's activities. The appointment of Alexander Acosta, the prosecutor who negotiated the NPA, to the Trump cabinet as labor secretary, and the subsequent handling of the revelations about the NPA under that administration is a documented part of the political record. The Biden Justice Department's handling of ongoing Epstein-related legal matters, including the prosecution timeline, the documents release, and related proceedings, has been criticized by victims' advocates as insufficiently aggressive, though the department has pointed to the complexity of the cases and the constraints created by Epstein's death. On the international stage, Prince Andrew's relationship with Epstein and the British royal family's handling of that relationship constitutes one of the most significant royal controversies of the modern era. Andrew was stripped of his military titles and royal patronages. He is no longer a working royal. He has not faced criminal charges in any jurisdiction. Israeli political figures connected to individuals in Epstein's orbit, including the intelligence-adjacent relationships discussed earlier, have remained largely outside the frame of American media coverage of the case. though investigative journalists in Israel and elsewhere have reported on these connections in detail. The political dimensions of the Epstein case do not resolve into a neat partisan narrative. They resolve into something more disturbing. Evidence that access to extreme wealth and social connection is its own political category, one that transcends party, that transcends ideology, and that creates a parallel legal universe in which different rules apply. The NPA was not negotiated because Epstein was a Democrat or a Republican. It was negotiated because he was rich, connected, and represented by attorneys who understood precisely how those two things could be leveraged in a specific institutional context. That is not a partisan failure. It is a systemic one. There is a thread running through the entire Epstein case that deserves more attention than it typically receives. The extraordinary, sustained, often lonely effort of the survivors to force the system to acknowledge what it had failed to do. This is not a story in which the victims sat quietly and waited for justice to arrive. This is a story in which the victims, mostly young women without resources, without legal infrastructure, without famous names or powerful allies, spent years, and in some cases decades, demanding that institutions designed to protect them fulfill that obligation. Courtney Wild was 14 years old when she was abused at Epstein's Palm Beach home. She became the lead plaintiff in the lawsuit challenging the NPA's compliance with the Crime Victims' Rights Act. She sat through depositions. She gave interviews. She stood in front of cameras and told her story repeatedly at enormous personal cost, because she had decided that the deal that had been made without her knowledge and without her consent was not going to stand unchallenged. When Judge Marr issued his ruling in 2019 that the government had violated the victims' rights, Wild was in the courtroom. She had been waiting for that ruling for years. Virginia, Jeffrey pursued civil litigation against Ghislaine Maxwell for years before the settlement. She pursued a separate lawsuit against Prince Andrew, one of the most legally and socially consequential suits filed in Britain in recent memory. She has given interviews to 60 Minutes Australia, to the BBC, to print journalists around the world. She has been subjected to the full force of defamation accusations, of social media harassment, of every tool that powerful and well-resourced individuals use to discredit accusers. She has not stopped. Annie Farmer testified at Ghislaine Maxwell's trial. Maria Farmer, who made the original FBI report in 1996, has spoken extensively to journalists about what she experienced and what she observed. Sarah Ransom has been vocal in her advocacy for other survivors, in her criticism of institutions that enabled Epstein, and in her push for the full release of all documents related to the case. The organization Rise, led by victims' advocates, has pushed for legislative reforms to close the loopholes that made the NPA possible. Changes to the Crime Victims' Rights Act that would make future non-prosecution agreements of this kind more difficult have been the subject of congressional discussion, though comprehensive legislation has not yet passed. The Epstein Victims Compensation Program, established as part of the settlement of claims against Epstein's estate following his death, distributed funds to more than 100 claimants. The process was criticized by some victims and their attorneys as inadequate and as designed to minimize payouts rather than to genuinely compensate those who had been harmed. But it represented a formal acknowledgement, backed by a financial commitment from the estate, that the harm was real and that it was owed some remedy. None of this is enough. The survivors, many of them, have said as much. Financial compensation, while meaningful in practical terms, does not constitute the kind of accountability that a criminal trial and conviction would have represented. The people who enabled Epstein, who recruited for him, who transported his victims, who provided him social cover, who negotiated his deal, many of them have not faced criminal proceedings of any kind. The survivors' fight continues, and it is worth saying plainly, the reason we know as much as we know about what Jeffrey Epstein did, about how his network operated, about the specific details that make this case comprehensible rather than abstract, is almost entirely because of the women who refuse to stay quiet about what happened to them. Not because of prosecutors, not because of institutions, not because of any government agency or university or financial institution that could have acted sooner and chose not to, because of them. The word cover-up gets thrown around so often in contemporary discourse that it has lost some of its weight. So let me be specific about what I mean when I say that there was a cover-up in the Epstein case. I mean a series of documented decisions made by individuals and institutions with the knowledge and the power to act differently that had the effect, whether or not this was a primary intent in every case, of protecting Jeffrey Epstein from the full consequences of his conduct and protecting others who might have been implicated had a full prosecution occurred. The Palm Beach County State Attorney's decision not to prosecute following Detective Reed Carey's investigation is documented. The rationale has never been satisfactorily explained. The non-prosecution agreement is documented. The failure to notify victims as required by law is documented. A federal judge has found that the victims' rights were violated in the negotiation of that agreement. The work release arrangement that allowed Epstein to spend 12 hours a day outside a county jail while serving his sentence is documented. The Palm Beach County Sheriff's Office, which authorized those arrangements, was later the subject of a state audit that found the arrangement was not justified under the applicable standards. The decision to take Epstein off suicide watch, despite the July 23rd incident in his cell, is documented. Who made that decision, under what authority, and on what basis, has never been fully and publicly explained. The failure of the Bureau of Prisons camera systems on the night of Epstein's death is documented. The simultaneous failure of 2 guards to conduct required check-ins is documented. The failure to replace Epstein's cellmate after the transfer of Nicholas Tartaglione is documented. The decision by MIT's Media Lab to conceal the source of Epstein's donations, labeling them as anonymous to avoid association with registered sex offender, is documented in internal emails published by The New Yorker. J.P. Morgan's continued banking relationship with Epstein after his conviction, and the processing of transactions that civil plaintiffs allege were related to his trafficking operation, is documented. The bank settled for $290 million. Deutsche Bank's similar continued relationship and the failure of its internal compliance systems to flag suspicious transactions is documented. The bank settled for $75 million with the New York Department of Financial Services. Each of these is a documented decision. Each of them had the effect of prolonging Epstein's ability to operate, of limiting the legal consequences he faced, or of obscuring the full scope of what he had done. Whether each was made with conscious intent to protect him, or whether some of the product of institutional dysfunction, negligence, or ordinary human failure in the face of complexity, The effect was the same. The silence that accumulated around Epstein's operation over 3 decades was not a natural silence. It was a constructed one, built brick by brick, decision by decision, from the local courthouse in Palm Beach to the highest levels of federal law enforcement, through the boardrooms of global banks and the endowment offices of elite universities. And the question that this documented silence poses, a question that the full institutional reckoning this case deserves, has not yet answered, is whose interest did that silence serve? This is where honesty requires acknowledging what we still don't know. We do not know with certainty how Jeffrey Epstein died. The forensic dispute between the official medical examiner and Dr. Michael Baden has not been resolved. No independent criminal investigation with the power to compel testimony and access to all physical evidence has reached a public conclusion that definitively establishes either suicide or homicide. We do not know the full extent of what was recorded. The cameras found throughout Epstein's properties, documented in court filings and described by investigators, represent a potential trove of evidence whose contents and whose ultimate disposition remain unclear. If recordings existed, where are they? If they were seized during the 2019 search of the Manhattan townhouse, what did they show? If they have been reviewed by any law enforcement or intelligence entity, the results of that review have not been made public. We do not know the full scope of Epstein's financial arrangements. Despite settlements with J.P. Morgan and Deutsche Bank, the full map of how money moved through the Epstein network, who received what, for what purpose, under what structures, has not been publicly reconstructed in its entirety. We do not know the full details of his client list, whether J. Epstein and Company had real financial clients, and who those clients were, and what the actual financial relationship between those clients and the operation might reveal about the network's funding and purpose, remains partly obscure. We do not know whether the intelligence allegations have any documentary basis. The claims that Epstein operated as an asset of any intelligence agency, made by multiple sources, some more credible than others, have not been verified through declassified government documents or through any official investigation with public findings. We do not know what Ghislaine Maxwell has not told. She has access to the most intimate knowledge of how the network functioned, who was involved, and what documentation may exist. She has not cooperated with the government in any publicly disclosed way. Whatever she knows, she has chosen not to say. We do not know whether all of the individuals implicated in victim testimony as having engaged in criminal conduct with minors will ever face legal consequences. Several names identified in testimony given under oath, in court proceedings or in depositions that have been authenticated, have not been charged with any crime. Whether that reflects a prosecutorial determination that the evidence is insufficient or whether it reflects other considerations is not publicly clear. We do not know what was in the full flight logs. The partial release of log information has produced significant public analysis, but a complete, unredacted record of every flight on every aircraft in the Epstein fleet has not been made fully public in a form that has been comprehensively analyzed and reported on. These open questions are not a reason to despair. They are a reason to demand. To demand that the institutions with the power and the obligation to answer them do so, publicly, completely, without further delay. The victims of Jeffrey Epstein's operation have waited long enough for a full accounting. They waited while he operated. They waited while his deal was negotiated. They waited while he served a barely there sentence. They waited while he returned to his life. They waited while he was prosecuted, and then died. And then the people around him were prosecuted in a proceeding that, however significant as a legal matter, left vast swath of the network entirely untouched. They should not have to wait any longer. So here we are, at the end of a story that started with a math tutor from Brooklyn and wound its way through private islands and royal palaces and federal courtrooms and maximum security prison cells. A story that touches the highest offices in the world and the most violated corners of the most private rooms you can imagine. A story that is, depending on where you stand, about individual evil or about systemic failure or about the specific and peculiar vulnerability of power to its own corruption. I want to leave you with something more than outrage. Outrage is easy. Outrage gets views, gets shares, gets the momentary satisfaction of righteous anger, but it doesn't produce change. And change, systemic, durable, structural change in how this country handles sex trafficking, how it handles wealthy defendants, how it handles victims, how it handles the institutions that fail those victims, is the only thing that would give the suffering documented in this story any meaning. Here is what this case revealed, in terms that I think every person watching this can hold on to. First, the system is not broken in random ways. It is broken in ways that consistently protect people with money and social connection. The failures documented in the Epstein case, from the Palm Beach State Attorney's decision not to prosecute, to the NPA, to the work release arrangement, to the banking relationships that persisted post-conviction, did not happen by accident. They happen in a context in which every decision-maker at every level was aware of who Jeffrey Epstein was, who he knew, and what resources he could bring to bear in any adversarial proceeding. The system bent in the direction of the powerful, as it reliably does, and the consequences fell, as they reliably do, on the least powerful people in the room. Second, institutions do not self-correct from the inside. J.P. Morgan did not exit the Epstein relationship because a senior executive looked at the account and said, "This is wrong." They exited, partially, imperfectly, after a settlement that cost them $290 million and enormous reputational damage. MIT did not reconsider its relationship with Epstein because its leadership examined his criminal record and concluded it was incompatible with institutional values. It reconsidered after Ronan Farrow's reporting made the relationship a front-page scandal. Harvard continues to process the complexity of a relationship that its own review found was far closer than it should have been. Institutional self-correction, in these cases, came from outside pressure, from journalism, from litigation, from public accountability, not from internal ethics. Third, victims are the most important witnesses in any story about powerful abusers, and they are consistently the least protected. The women who were abused by Jeffrey Epstein were not treated as the center of the legal and institutional response to his conduct. They were treated as an inconvenience, as complications to be managed, as claimants to be settled with at the lowest possible cost, as people whose discomfort with an NPA they didn't know existed was unfortunate but legally manageable. The Crime Victims' Rights Act was violated, It took a federal judge to document that fact years after the violation occurred. The system was not designed with them in mind, and the reform agenda that emerges from this case should have their experience at its center. Fourth, accountability requires transparency, and transparency requires journalism. The Miami Herald and Julie Kay. Brown broke this story open in a way that the legal system, after years, had failed to do. The New Yorker's reporting on MIT forced an institutional reckoning. The release of court documents, fought for over years by victims' attorneys, produced public knowledge that had no other pathway to daylight. If there's a lesson in the infrastructure of the Epstein story about how accountability actually functions, it is that free, funded, independent investigative journalism is not a luxury. It is a mechanism of justice when the official mechanisms fail. Fifth, the open questions matter. The fact that we do not know how Jeffrey Epstein died, that we do not know the full content of the recordings that may have been made at his properties, that we do not know whether he was in any way operating at the direction of an intelligence agency, that we do not know what Ghislaine Maxwell knows and has chosen not to say. These are not questions to put down. They are questions that the institutions responsible for answering them have an obligation to answer, and that obligation does not expire. The victims of Jeffrey Epstein's operation are still alive. Many of them are still fighting. Some of them have found degrees of healing. None of them have found what a real reckoning would look like. The kind of reckoning in which every person who was complicit faced a consequence proportionate to their complicity, and the systems that failed them were reformed in ways that made their failure harder to repeat. That reckoning has not happened. The question of whether it ever will is not just a question about Jeffrey Epstein. It is a question about whether the institutions of a democratic society, its courts, its prosecutors, its financial regulators, its universities, its journalism, its government, are capable of holding power accountable when the subject of that accountability is a man whose network stretches deep into every one of those institutions simultaneously. That is a hard question. It is an uncomfortable question. It is a question that powerful institutions and powerful individuals would prefer you to be too distracted to ask. But the girls who were brought to those houses, who were flown on those planes, who were told that what was happening to them was normal or their fault or something they had agreed to, they deserve for you to keep asking it. They deserve for all of us to keep demanding the answer. This story is not over. It won't be over until the full truth is told. And that truth, whatever it turns out to be in its complete form, is still out there in sealed documents, in unreleased recordings, in the silence of a woman serving a 20-year sentence in a federal prison in Florida, in the classified files of agencies that have not been compelled to share what they know. It is out there, and somebody should be fighting to bring it into the light.